Hello, welcome back to War Wars 101. Today, what I'm doing is I'm going on to the court's website. It is September 22nd, 2025. I'm doing let's see, it's a First Amended Verified Petition for Writ of Administrative Mandamus, and this is under CCP Section 1094.5. So I'm getting ready to do this right now and file it in with the court. And then I'm also going to show you pretty much what this is all about. Okay, so and just to give you a little bit of background, I did the original case, and which case number is this? So when I did the original case, or when I did the original filing, it wasn't correct. I knew a lot of it wasn't correct, but I got it in. And then you have the right, the city did a demur. So a demur is basically when they're saying that you haven't properly pled a cause of action. And so then they basically try to get the case thrown out. So you have the right to your First Amended complaint without asking for leave of court. And that's any time before the demur hearing. So the demur hearing was scheduled for September 30th, 2025. So today I'm just getting this in, and this will pretty much wipe the demur off of the case. Okay, so let's get down to, okay, let's see. We're going to file in the case. Okay, so that's the case number. And let's see that first document. We're going to call it a verified. So I'm going to go right in here. So it's called First Amended Verified Petition. So let's see, it's probably not, I always like to type it in, but see, that's probably not in there. Amended. So that's not even there. So we're going to put in, let's see, amended. Amended complaint could be one, but I don't like that. So let's go see if we see a petition. Because the court clerks get picky about this. See, so now I'm looking right here. Petition. I don't know what those mean. Petition for writ of mandate. So even though it's the first amended, that might be good enough. Okay. I think that's the one I'm gonna do it under. Petition for writ of mandate. Why is it saying that? Oh, I was gonna fill in the name. Okay. Now, let me go to, I know I just put this over here. Which one was it? Okay. So that's the fee. It's a fee waiver. Okay, first, nice exhibits. First amended. So I have this in my save file. So I'm gonna upload it. And now, okay, so that's the petition for writ of mandate. That's in the system. What I'm gonna do is go, oh no, that's the proposed order. Got the wrong one. That's why I always check. Okay, so edit. How do you edit this? Cancel. No, I want to replace form. Here, replace document. I knew there was something like that. Okay. Thought I had the right one. This is first amended. Yeah, that's the right one. This is it. I think this is it. The first page should be a notice. Let me see. So I'll read it while we're here just to go over it. So, okay, so this is the court case. Again, this is my caption up here. This is the court we're in, Stanley Moss, Rodney Ruzan versus the Los Angeles World Airports, a city of Los Angeles, a municipal corporation, and the Los Angeles Civil Service Commission. And I just put this cover on here to give the court clerk notice of what I'm doing in the case, because there could be some confusion. Like I said, there's a demur hearing coming up. But due to the fact I have the right to my First Amendment complaint, I think I have it squared away now. So this will be the operative complaint once it's filed in and it wipes off the demur and everything else. So to all parties, please take notice that pursuant to the Code of Civil Procedure, Section 472, Petitioner Rodney Ruzan hereby files his First Amended verified petition for writ of administrative mandamus under CCP 1094.5 in this action. The petitioner exercises his statutory right to amend once without leave of court prior to the hearing on the respondent's demur. The filing of the First Amended Petition renders the pending demur moot and removes it from the court calendar. That's dated today. Rodney Ruzan. All right. So same caption on the next page. And now I'm going to show you, this is my argument here. Introduction. The petition is brought pursuant to the Code of Civil Procedure 1094.5 for judicial review of the adjudicatory administrative decision. Petitioner challenges the Los Angeles Civil Service Commission's final ruling sustaining a charge or his discharge as void ab initio because he was denied the fundamental right to be heard. Retaliation against the petitioner for his whistleblower disclosures forms part of the background context. It shows the motive and the prejudice, but is not asserted here as a separate claim. The central issue in this writ is due process. The commissioner's categorical exclusion of petitioner's defense evidence deprived him in a meaningful hearing. Parties. Petitioner Rodney Ruzan is a resident of Los Angeles County and a career airport police officer, employed by the Los Angeles World Airports for more than 20 years until his unlawful discharge. Respondent Los Angeles World Airports is a proprietary department of the City of Los Angeles and petitioner's employing agency. Respondent City of Los Angeles is a municipal corporation that oversees LAWA and the Civil Service Commission. Respondent Los Angeles Civil Service Commission is a charter created body that adjudicates disciplinary appeals of the city employees. The jurisdiction and venue. The court has jurisdiction under Article 6, Section 10 of the California Constitution and Code of Civil Procedure, Section 1094.5. Venue is proper because the court, venue is proper in this court because the commission's proceedings occurred in Los Angeles County and the respondents are located here. Timeliness of petition. The commission voted on February 27th to sustain petitioner's discharge. On March 3rd, the commission certified and mailed its final ruling to petitioner. Under CCP 1094.6, the 90-day limitation period runs from when the decision is delivered personally or deposited in the mail. Petitioner had no notice until March 3rd, 2025, when the decision was mailed. But petitioner's petition filed May 29th is therefore timely. The First Amended Petition filed on September 19th, 2025 relates back to the timely filing of the original petition under CCP section 472. I'm going to have to fix that because that's not correct. So I'll fix that right before I send it out. The new date on this is September 22nd. Okay, beneficial interest. The petitioner's beneficiary interest within the meaning of CCP 1086 and 1094.5 is the employees directly discharged by the challenge ruling. Petitioner's vested right to a public employment, livelihood, and statutory protections are directly and adversely affected. Factual allegations. A. Whistleblower disclosures and early retaliation. On June 7, 2022, petitioner received a memorandum signed by LAWA HR Director Minerva Gutierrez threatening to place him off duty without pay for alleged noncompliance with the COVID testing. Petitioner wasn't in compliance. To document this, petitioner sent an email with proof of testing. On June 22nd, 2022, petitioner requested the governing guidelines relied upon in the memorandum. Gutierrez responded on the same day, producing two guidelines purporting to be official city requirements. Affidavit testimony from Officer David Rogers and a Public Records Act response indicated the documents were not formally adopted. On August 11, 2022, petitioner filed a whistleblower/EEO complaint concerning these documents and other issues. On August 23, 2022, Investor David Barraway acknowledged receipt of the complaint but included Gutierrez and HR staff on his reply. On August 25, 2022, petitioner disclosed to Investigator Barraway information that he reasonably believed evidenced violations of Penal Code Sections 115 and 524. Specifically, that the use of fraudulent compliance documents relating to the COVID-19 requirements. Later that day, Captain Mario Patrick arranged for petitioner to be referred to the LAPD Behavioral Science Services. A transcript excerpt documents this referral. Dr. Mars conducted a brief evaluation, found petitioner fit for duty, and petitioner returned to work. On August 26, petitioner completed his assigned duty shift from 0030 hours until 0630 hours. Then on August 27th and 28th, 2022 were his regular days off. On August 29th, 2022, petitioner returned to his duty at 17:30. That's at night hours. During that shift, he was dispatched to investigate a reported battery at the Van Nuys Flyaway, as reflected in official unit history call log. The incident resulted in a lawful arrest of the subject through a private person's arrest. Immediately afterwards, Sergeant Beacom and Lieutenant Eno removed petitioner's police powers, confiscated his firearms and credentials, and served him with a memorandum placing him on an administrative assignment and restricting him to his home. The memorandum cited petitioner's recent statements to Barway. Petitioner had no prior record of discipline or condition affecting his ability to perform duties. Okay, March 14th, 2023, letter placing department on notice. On March 14th, 2023, petitioner submitted a written notice addressed to Chief Cecil Ramble Jr. and 8 other department officials directly involved in the case. In this letter, petitioner expressly evoked his rights under the California Labor Code section 1102.5, objected to being deprived of his peace officer powers without due process, and identified the retaliatory nature of the actions being taken against him. Petitioner further stated that he was being retaliated against for reporting criminal misconduct by high-ranking city officials, and that the department's conduct violated his constitutional property interest in his continued employment. By sending this letter to multiple high-ranking officials, petitioner ensured that respondents were fully on notice of his protected disclosures and due process objections well before the Civil Service Commission hearing. Despite this notice, the Commission's hearing officer later issued a blanket ruling excluding all evidence of any type relating to whistleblower complaints, thereby silencing the very defense petitioner had raised months earlier. C. Disciplinary process and use of the whistleblower materials against petitioner. On May 31st, 2023, petitioner filed a crime report with the LAPD and notified LAWA management. 16 days later, he was served with a notice of interview. On February 8th, 2024, petitioner filed an opposition to the notice of intent to discharge. LAWA relied upon Addendum 12 of the Scully package, which introduced petitioner's whistleblower notices as evidence. In the September 2024, petitioner filed a notice of defense, asserting his rights under the statutory whistleblower protections, POBRA, and constitutional guarantees. Now, the hearing officer's blanket exclusion of defense evidence. On September 18th, hearing officer Sherry Ross issued a corrected ruling stating verbatim, no evidence of any type with regard to the COVID, complaints about the COVID vaccine mandate, communications about the COVID vaccine, documents pertaining to the COVID vaccine mandate, fraudulent documentation regarding the COVID vaccine mandate, Labor Code Section 1102.5, and or whistleblower claims will be heard during the hearing in the appeal of the appellant's discharge. This ruling barred petitioner from introducing evidence or testimony in support of his defense. At the same time, respondents relied on petitioner's whistleblower notice as evidence against him. Petitioner alleges that this exclusion denied him of the right to be heard on the issues central to his defense and rendered the hearing unfair. Exhaustion of administrative remedies. Petitioner has fully exhausted all available administrative remedies. The Los Angeles Civil Service Commission voted on February 27, 2025 to sustain the petitioner's discharge and thereafter certified and mailed its final decision to petitioner on March 3rd, 2025. Under Civil Code Section 1094.6 Subdivision C, the Commission's decision became final upon that ruling. No further administrative review is available. Accordingly, the petition is properly before the court. Causes of action. The first cause of action, abuse of discretion, CCP, Section 1094.5. Respondents acted in excess of jurisdiction, failed to proceed in the manner required by law, and issued findings not supported by the weight of evidence within the meaning of CCP, Section 1094.5, subsection B through C. The hearing officer blanket order excluding whistleblower-related evidence denied petitioner his constitutional right to be heard on matters essential to his defense. This was not a mere evidentiary ruling. It was a categorical prohibition that deprived the hearing of its constitutional character. Because the opportunity to be heard is the minimum requirement of due process, Scully versus State Board, the proceeding lacked the elements necessary for a fair trial. Where do where due process where due process is denied, the decision is void ab initio, not merely voidable. Second cause of action, denial of due process. Petitioner realleges and incorporates paragraphs 1 through 45 as though fully set forth herein. The California Constitution guarantees that no person may be deprived or of a protected right within due process of law. At minimum, due process requires notice and opportunity to be heard. Due process also requires a meaningful chance to present evidence and confront the evidence offered against a party. Today's fresh start, Supra, 5-7 Cal, fourth at 212. Okay, and then we also have respondents denied petitioner this right when the hearing officer ordered that no evidence of any type relating to the whistleblower complaints or fraudulent COVID-19 forms would be admitted. This order prevented petitioner from presenting his defense and denied him the opportunity to be heard on central issues. By not allowing the petitioner to be heard, respondents failed to proceed in the matter required by law and deprived him of a fair trial within the meaning of CCP Section 1094.5B. Because denial of the opportunity to be heard is a jurisdictional defect, the Commission's ruling is void ab initio and without legal effect, not merely voidable. My prayer for relief. Wherefore, the petitioner prays for judgments as follows: for issuance of a preemptory writ of mandate, CCP, Section 1094.5, directing respondents to vacate and annul the final ruling of the Civil Service Commission as void ab initio. Further, reinstatement to petitioner's formal position with full back pay, benefits, seniority, and all other emoluments of employment. For expungements of all references to the challenge disciplinary action from petitioner's employment records, for costs of this suit, and for other such relief as the court deems proper. And then I have the exhibits. And then what's also important, this has to be verified. I, Rodney Ruzan, am the petitioner in this action. I have read the foregoing First Amended verified petition and know the contents thereof. The same is true of my own knowledge, except as those matters stated on information and belief. And as to those matters I believe them to be true, I declare under penalty of perjury of the laws of the state of California that the foregoing is true, executed 22nd day of September 2025 at Lancaster. Okay. So I see I have to, I'm glad I reread that, but that just gives you a little bit of what I was doing there. I'm gonna have to get another one of those after I fix it. Actually, let me fix that right. All right, let's go in here and look at it again. Make sure we get in the court the right one. Where is that? September 19th. We talked about September 19th. There. Bam. September 22nd. And let me make sure I got a signature on here. Okay. Good. All right, so now we got that one done. We have to add a document. I think I have 4 documents. So let me think. Okay, the other one, maybe, okay. That's one. All right, let's see what I got here. Okay, I got a fee waiver. I have to do another fee waiver because I need to get the transcript. I don't really think I need it in this because it was a violation due process, but you still have to get the transcript from the city. And now we're going to get into, what's the other document? Like 4 of them. Um, oh, I don't know if I compressed those exhibits. How big are those? What's the size? Show more information. 19 point, I think it'll go in at 20. Okay, it'll go in at 20 or 25, it'll take it. I'm right on size. Okay. I always have problems with the exhibits are always a problem because they get big, so I have to compress them. Because I think this can take like 20 or 25 megabytes. And that's as big as it can get. So I just have to stand by and wait here. Okay. So that went in. Now we're going to get to, okay, so I got the exhibits, proposed order. See, so I got the moving paperwork. This would be the request for waivers. This would be, what did I just say this was? The exhibits. Okay, let me see. Check them. All right, exhibit list. It should be like 125 page. Yeah. It's exhibit 1, 2. Okay. Bam. That's how I do all my exhibits. I like to put that blue page in there, make it easier for the judge. Okay. So that's the exhibit list. So then I think I have I know I got one more thing, a proposed order. Yeah, it should be the proposed order. What does that say? Nope. Nope. I hope I got it in here. This looks like it says proposed. Man. Get older, you lose your eyesight. Okay, let me see. So I think this is the proposed order. Oh, why can't you open it? All right, so it's there. Bam. That's the proposed order. Immediately get me reinstated. Okay. All right. Good. So I think I got everything right there. Let's put, okay, so this is the exhibit list. There, I saw it. Okay. And then we're going to put in proposed, propose order. 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 Is there order petition? Maybe there's a petition. Let's see, petition order. It'll be petition. Am I spelling petition wrong? Petition, nope. Petition. Is there a petition order? Petition. And we're gonna just be simple with this. Just gonna go into order. Just gonna give it a name. So it's easiest when I just do this, right? So I just get the name off of here, and then they can't. It says exactly what it says. Copy. Hopefully it copied. Bam. Bam. Okay. I'm done adding. So choose party as filing Rodney. I already have a fee waiver. I'm just putting another one in because that's for the court transcripts that you need from the Civil Service Commission. Okay, request for court reporter services. No. Okay, yeah. Request for, that's not, I already have. Okay, this is the, oh, interesting. Okay, each one. Those are city attorneys who will see it. Those two will see it. Right when it goes in, that'll be the e-filing, so they'll get an email and seeing it. Damn. Oh, I hate when they do that. Okay, they want a Word copy. Okay, that's the right one. Okay, so finally we're gonna go down here. Everybody, all right, so now you gotta hit the payment thing again. Passed. We should be good. All right, we're good to go. Bam. So it's all done. So that's it's pretty much all done now. I just got the email, so everything's in, and then we'll pretty much now we'll see. I'm pretty sure the city, it's my anticipation they'll be moving to Demur. There was some issues with the timing in the 90 days, so I got the feeling they'll be harping on that. But they're definitely going to want to demur and not want to answer because they don't want to get into the merits. And that's oftentimes what I look at in the legal battles. It's not even about which writer is wrong. I think it's becoming pretty obvious that the forms that I was even speaking of, they don't have any certified forms, and this is exactly what I was reporting. And they're taking every single strategy that they can think of to not answer that simple question. I mean, if they had certified forms, why don't you just give them up? So I'll be doing right in the next video. I have for a violation of the California Public Records Act. I'll be doing that here in the next few minutes. I got to file that in today as well. All right. So if you like what you're seeing, like and subscribe. Keep following along with this journey. It's a whole lot more to come. All right. See you in the next video.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.